Okay. Well, welcome everyone to the bright and early session from Citations to Citators, how AI is reshaping legal research. We are with the Free Law Project. Free Law Project is a nonprofit that uses technology, data, and advocacy to democratize access to legal information. Today, I am the moderator. I'm Jessica Frank. I'm a project manager. And with me, I have Rebecca Fordon, William Palin, and Rachel Gao. Rebecca is a law librarian at Moritz Law Library and an assistant professor of professional practice at Ohio State University. She's also a Free Law Project board member. Today, Rebecca is going to be setting the stage for our conversation and explaining the big picture goals behind building an open source citator and providing insight into the current landscape of legal citation tools. Then we're going to hear from William Palin, an attorney, software developer, and case law project lead at Free Law Project. Bill is going to dive into the nitty-gritty of data collection and cleanup at Free Law Project, shedding light on how citations are extracted from court documents and preparing data for the citator. And then Rachel is an AI and machine learning developer at Free Law, and she's going to take us into the AI-driven side of things. Rachel's going to walk us through the models, the prompts, and the human-in-the-loop processes that power this citator, sharing her expertise on natural language processing, machine learning, and large-scale data analytics. All right, so as moderator, we're going to ask through a series of questions. If you have questions or you want to interrupt, I think it's okay for the panel at the moment in which you want to do it. So we have a series of questions. So to get started, I'm going to tee it up to Rebecca with, can you walk us through the legal field and why we need an open source citator now?
Yeah, sure. And I think I'm actually just going to stay here because I can see.
There are mics for the.
Oh, then Mike. Yeah.
I think there's a handout.
Yeah, there's a handout. That's not wonderful.
There was a handout.
That's all right. Although
I guess Elmer, the question is like, do the mics pick her up there?
Yeah, it's picking up. So
Okay, I'll stay here then. Okay, so I guess the first point I want to make is that open data spurs innovation. And so we've already seen this with our case law data. So I have a slide, go to that first slide here. Okay, so here's what kind of legal research looked like just before AI hit the scene. So this is from Sarah Glassmeyer. This is like an updated version of her chart. You can go see it on her page and everything she says about it. But this goes all the way back to the 1980s. She's got an older version of it that goes even far back in print publishing. But basically, like, they've all consolidated into a few companies right now. But then what happened when I think two things happened at once. There's a lot now. Like, I have my own little tally of all the new legal research companies that I've heard about, and I'm sure all you have seen this too. There's so many. And I think it's something we haven't seen before. Like, you could see a few little blips in here of smaller companies, like Ross is there, Revell is there, Judicata is there. P6 is there a little bit longer. They probably made the best exit out of things. So today we see so much more. So, like, why is that? And so one big part of it is Harvard did this project with Revell, actually, that I'm sure most of you have heard about, to scan every case in their library and make it into data. And so that finished in like 2018, 2020, like they scanned it through then. But then they didn't make it commercially available until 2024. That was part of like Revell's deal. They wanted exclusivity, and then Lexis got exclusivity for that time when they bought them. So that went public in 2024. So I think that's a huge part of where all this is coming from. And then Court Listener takes it from, we've been collecting all of this data for a long time too. So like appellate court cases, and now we can connect them to the print and to the print reporters. So we've got all this data and people are using it. So you do the next slide. So these are just a few of the people who come to Free Law Project and say, can we use your data? And so they're doing like really cool, innovative things. Like Describe is, it's free right now. And they are doing case summaries of every single case in their database. And then now they're building on that more. They made a really fun little tool called the Citationator, where you can upload a brief and it will try to find any cases that don't exist in actually Free Law Project's database. They connect it through some of our tools. So just like really incredible innovation that is happening. And Midpage actually made a whole citator. So they have like their own AI citator. So like people are doing cool stuff with our data. I guess the other thing I would say is that, so one piece is spurring innovation, one piece is researchers. So right now, researchers who want to study, there's all these empirical legal studies people who, you know, study everything under the sun, and maybe they want to look at, like, is someone more likely to be reversed? Is someone more likely to be criticized, like individual judges or individual courts? It's really difficult to do that right now because that data is not widely available. So so we can help with that, and people are already using our citation network data. So I'll talk a little bit more in a minute about what we already have, but people are already using the data we have to do incredible things. So just imagine what they could do if we had this more rich data.
So then the current citation falls short on paywall, openness, API access. But okay. Do you want to cover the key components of a citator, or your
let me say like a little bit more about those.
Okay.
So like paywall, so I already mentioned kind of like the innovation piece, but I just want to say, like, as a librarian, I'm sure people in this room are librarians who have had this conversation too. When someone comes to me and says, like, oh, can I use one of these new legal research tools, like one of these fancy tools that have come out? Like, could I just use Describe? It's free. Or could I use like case text back in the day? Or can I use Paxton or whatever? I'll always say, like, yes, but you know, be careful to still cite check your cases and use like a real citator. And so that's what I always said. I started to sort of modify my view a little bit, but like they still then need Shepard's or T-Cite. And I think most people would give that advice. Like, you still do need to check your cases. And that's what's expensive for lawyers. So even lawyers who, you know, fast case now VLAX, as many bars use that. They have a citator. It's not quite as good as Lexis and Westlaw. I think probably most people would still use Westlaw or Lexis. So they still need to get that Westlaw or Lexis subscription for that purpose. And then, yeah, I think I covered kind of like an API access thing. Like, people can't easily access that stuff. So like they can access the citation network stuff through us, but they're still can't access the data of how cases treat each other.
with the existing citators, the AI changing.
I'll talk about these for a second. So I kind of mentioned the traditional ones, and then these all alternative ones, and then the newer AI citators that a few companies have started coming out with. So I wanted to mention like how they work and how they work differently, and I think that's kind of like influenced the direction that we've taken a little bit. So like traditionally, the way citators are created is for people to read every opinion that comes out and read the opinion, and it says like, we hereby overrule whatever, and then you go into the overruled case and add a little tag to it. So that's the way it worked for a long time. And as computers it came about, they made that easier because they could suggest like hey, they've got like the word overrule right next to the case, maybe you want to take a look at that one. And so they've made the work of the editors easier, but editors are still involved in Westlaw and Lexis. Like they still hire people to do that and to look at that and to like oversee that whole process. There were some that didn't hire editors at all. So like case text, when they started doing theirs, they did not hire editors. They just tried to do it all with AI. Fast case, they had their bad law bot for quite a while. Like famously, they said, we're not doing it and we're not hiring it. Like we're just using an algorithm. If this is helpful to you, great. If not, like great. They knew that it wasn't perfect. But as the technology gets a little better or much better, like with generative AI, people have started to try to do it without editors at all and hope that it does a good job. So Paxton and Midpage I wanted to mention because they're both what I would call like ad hoc citators. So you can go to a case and you can say, check this and see if it's good law. And they'll go into their citation network and they'll pull all of the snippets to it and they'll try to do it like on the spot. But you still can't, look for like run a case law search and like filter it down to just cases that haven't been overruled. So you still can't do a lot of the things that you would hope to do with a citator with like these kind of ad hoc citators. Even though it's really exciting what they're doing.
Okay, thanks for laying that groundwork. And then Bill is going to talk about data foundation. So what does it take to create clean, consistent citation data across centuries?
I'm gonna stand up because too fidgety sitting down. Yeah, so we focus very much on data. I run our case law team at Relied Project, but I'm an attorney by training originally. And we focused for many years on data. And for example, we freed all of the Harvard data. We crowdsourced the collection of it years before it was actually released and integrated into our system with and I think I built an iPhone app for a certain number of people to download their 50 cases. And then we had, Dockerized containers for people who just wanted to put on their servers and run their daily collections. And we freed all that data. But more than that, and I've spent a lot of time looking at this data, we put a lot of investment in looking and building out our own databases to help us understand the opinions. So I would start with hundreds of hours of research on courts, historical courts, looking back. It's enabled us to actually find imaginary courts in the data. If you look on Lexis, you can actually find an imaginary district of Northern Washington that never existed. Forgive me, I didn't look this up before I checked. And it was like, oh, this is weird. And then you look and you see it's in Lexis and you look in the historical record and there's that court never existed, right? But we've done all that work on courts. We've done all that work building up open source tools on reporters as well. So the volumes, the historical record, and we used all of that actual information to build out a tool we call iSight, which is an open source tool. And so we've taken thousands and thousands of court data, 6,700-ish, a little more than that, different books that have been published, mostly in this country, one or two in England, because sometimes our law extended before the founding of the country, and sometimes things are cited back to British common law. And we all that put together with every regex pattern and everything in there allows us to sort of enhance the data, to look through it and to find things that other people haven't been able to find, or to do our best. So go to the next one. If you look at the math, I love looking at the math of it. The permutations for each pattern is astronomical. So we're talking trillions. Every time it runs through and looks and finds a reporter, we're not doing trillions, but it can do trillions of looks. So currently, this has sort of enabled us to pull out data that is now used by our team to extract things out. Currently, we're reprocessing 10 million of our opinions with these tools, and we pulled out hundreds of millions of of objects in the data that we've stored. So for instance, we have about 18 million known citations across our 10 million opinions. But we were able to pull out, actually, over the last week, we pulled out an extra 3 million unmatched citations. So citations that we were able to find within our system, but we don't know where they go yet, right? They could be parallel citations to match citations that we need to actually ingest and move them in. We've also connected 55, we made 55 million links between opinions. So we found a citation, we can put it over there, and we can actually talk about the depth of a citation link, how many times it's cited from one sub-opinion. So when I say sub-opinion, I talk about a dissent, essentially. In our database, we have a cluster is an opinion, like the document itself is a cluster, and each individual judicial writing is an opinion. So we link sub-opinions to sub-opinions. So we can helpfully find what is most important and what's most valuable, and you can see how this works with citations or with Citator. And then does everyone know a parenthetical when a judge sort of gives a brief description of the case? Using our tools, we're able to pull out 4 million so far parentheticals. So we like to think of these as who knows better what a law means than a judge who's citing to it. So we have tools we haven't fully released, but we have a parenthetical search, and all this information gives a brief, nice, non-AI driven summary of a case that we can use to actually build more sort of faster summaries of our opinions down the line. So that's sort of the guts of what we've done. And does anyone have any questions about any of these things? Okay, all right. So I think that's the data.
So we have the background, we have the data, and now Rachel's going to talk about training the AI, the models, the prompts, and the human in the loop. So we're leveraging AI to make building the first open source citator possible. What AI products are we using? Move on.
Yeah, so we looked into the possibilities of using either encoder classification models like BERT or generative large language models like ChatGPT. We thought about using the encoder models really for its scalability over really large corpuses. But ultimately, we decided that the generative model, as my co-panel mentioned earlier, is better suited for its task because of its superior reasoning skills, as well as the significantly longer context windows. As we all know, the opinions can be really long, sometimes hundreds of thousands of tokens long. They're often very complex, covering numerous citations, as well as pretty complex relationships. And often they use legalese that's not very easy to understand. So this makes generative models the perfect tool for this task. Once we narrowed down on the generative model approach, we experimented with a bunch of different commercial and open source tools. Listed here are the ones that we experimented: Claude, GPT, Gemini, Llama, Mistral, Amazon Nova, and Cohere. We compared the model performance based on its prediction quality, and ultimately we narrowed down to Claude, GPT, and Mistral, potentially having the capability to succeed.
So you mentioned that they were selected based on prediction quality. Can you elaborate on that, or how do we evaluate the LLMs, and when do we know that a model's result is good enough?
Yeah, so before I talk about evaluating the LLMs, I must first talk about the data, so we generated a set of human labeled data set of around 1,000 cited opinions covering around 130 citing opinions. We started with just the binary classification of overruled, not overruled, and really used the prompt engineering and ask the model to provide not only the predictions, but also the actual quotation from the original opinion itself, as well as the rationale as to why the model made a particular decision. As we know, there are a lot more not overruled opinions than overruled. So this class imbalance made us choose a metric that is a balance of precision and recall, which is called the F1 score. We did numerous rounds of experiments and adjusted the prompts as well as the data that's fed into the model. As you can see on the top left corner here, we started with an F1 score of 46% and ended up with an F1 score of 87%, which is a pretty substantial increase in performance. We've now continued to expand our classes, and now we're working on the expanded 9 classes. As you can see on the bottom left corner here, this not only covers the things that we would deem as bad law, but also things that we should be cautioned about, like distinguished or limited, as well as some of the neutral stuff like just cited or explained. During our once the citator is put into production, however, we won't have this human annotated data set for evaluation. So at that time, we will use either parallel models, which means we run multiple models in parallel to break the score, or use model as evaluator. This means using one model to evaluate the prediction of another model. The goal is to be able to flag uncertain predictions made by the model so that the user are informed by the model's uncertain predictions so that they can dig into further themselves.
So it sounds as if everything is going to be fully automated then with the AI models. So does that mean we no longer need the human in the loop that we had in the initial markup?
Absolutely not. We still very much need human in the loop. The AI citator and any of the AI product really are not meant to replace the human experts, but rather human experts are really a key asset into not only making the AI citator possible, but also really for it to flourish. I mentioned earlier that the data set we're using is a human annotated, expert annotated data set. This is not a once and done deal. We need periodic evaluations of the model to ensure the model quality hasn't digressed over time. This requires legal expertise to analyze the model predictions. And during production environment, we don't have this human annotated data set, so we should sample from the model predictions for experts review to ensure that the quality is still good. And I must acknowledge that, with using AI and as everyone here probably is thinking about the limitations and the risks, and we at Freelaw want to be, responsible developers and responsible providers. We try our best to minimize hallucinations and reduce any mistakes. But we want to be also transparent with our process, with the model, with the data, as well as the results. So, we welcome peer review of, any of the stuff. Everything is in the public domain.
So you talked about the model and the model results and the jump from in the F1 score. What techniques did you use to make that possible?
Yeah, so 2 things really made the big difference. The first one is data and the second one is prompts. I'm going to start with the data. So we know that a good model begins with good data. My co-panel Bill and his case law team have made substantial strides in enhancing the citations, not only to include additional citations that we didn't have before, but also to include reference citations. These are shorthand references to the cited opinions, as well as disambiguous any citations that might have similar citations or similar case names that might otherwise seem very confusing, as well as our opinions come from a bunch of different sources. So we need to make sure that the opinions are parsed and cleaned in a standard format so that the model can be provided with these opinions to analyze. Another point is, as we mentioned, our opinions are grouped into clusters, and we have the lead, concurrent, and dissent opinion. And one thing that made a lot of the difference in the model performance is to really separate the lead, concurrent, and the dissent opinion when providing to the model. and also give the model guidance on how to utilize these opinions to analyze the treatments. The next one is on prompt engineering. So we design our prompts following the best prompt engineering practices. We assign the model a role. For example, you're an expert legal citator. And we use very direct, detailed, and explicit directions, as well as clear definitions. And we also invoke chain of thought. And we repeat the instructions multiple times throughout the prompt with different formats, so the model really understands what we're saying, as well as we define a clear metric of success. And for really long prompts, we incorporate XML tags so that they're separated into separate sections. And we also use the multi-shot prompts so that the model is provided examples on how to analyze the opinions. We also ask the model to repeat after. So, we ask the model to output the instruction that is given so that it really understands what the instruction is, as well as to output not only the prediction, but also the quotation from the opinion and the rationale on why it made a certain decision. And also, as I mentioned earlier, we provide separate opinion types so that the model can, know that the lead opinion is the majority opinion versus the other ones are not. And our inputs are provided to the model in a structured format, and the model is also instructed to output in the predictions in a structured format for easy parsing and analyzing by experts. The best prompt that we have right now is around 1,500 words. So that is not, a one sentence or one paragraph prompt. And this is on top of the opinion body itself. The analogy that I like to use is it's like teaching a child a new skill. You want to be very clear and detailed, and you want to repeat yourself and also ask the child to repeat after you. So, as I mentioned, we want to be transparent and accountable. Again, the prompt is also available in the public domain. You're welcome to run your own experiments, and we also very much welcome suggestions and feedback.
So do you want to take a look at a few of the model predictions and talk about what's working well and what we're still struggling with?
Yeah, let's do that. On the next slide, we'll see there are two model predictions here. The first one is a successful prediction where the model correctly predicted the cited decision was overruled. And the second one was where the model failed to make a correct prediction. In the first example, you can see that the language of overruled is very clear from the body of the opinion itself. But if only all the opinions were this simple, right? So what we found to be helpful is to also provide the sub-opinions so that the model can utilize the concurrent and the dissent opinion in helping it to analyze the majority opinion. The second one is a example of where the model failed to make a correct prediction. If we were to only look at the first half of the quotation, where it says some of the same issue were presented before this court, we might decide that the cited opinion is simply cited by this opinion here. But if we read on further, we can see that the question was actually expressly waived in the cited opinion, which makes the cited opinion effectively distinguished. So, this is something that we should be cautioned, not simply just a neutral treatment. We have made substantial strides in enhancing the data quality, disambiguating similar case names, using prompt engineering, as well as provide examples to the models. A lot of times these cases where the model failed to make a correct prediction are close calls, even for human experts. And we found that enhancing the data quality is really what's going to push us forward in the right direction. And Rebecca has been tremendously helpful in providing expert annotated data points. But this is a huge task, and we always need more help in getting these expert annotated data points.
So we have some breaking news, top secret UI mockups of this tool. We anticipate it looking and being integrated with Court Listener. So can you walk us through those and how we're thinking about transparency and accessibility?
Yeah. So the citator is gonna be primarily presented in two views, which is the search result view as this and the cited by view. Before I dig into these, I just want to mention that these are really preliminary prototypes for us to visualize what the final product might look like. These are by no means the final predictions, and as you can see here, we still have a lot of work to do to provide a better user experience and also take accessibility into consideration. So on the left-hand side is the search result view. This is what you see when you search for a case law in court listener. You can immediately see what the treatment for the case is, as well as the metadata associated with it. You can see that the first one was reversed and the second one was simply cited. And when providing these treatments, we analyze the, all the opinions that cites this particular opinion, and we only present the most severe and recent treatments so that the user has the most recent information to work off of. And on the left-hand pane, there is a filter section so that the user can also filter to exclude any treatments that they don't want to see. For example, if they don't want to see anything that's overruled. Or you can also filter for only things that's being overruled. On the right side is the cited by view. This is what you see when you look at a particular case, and these are all the subsequent opinions that cites a particular decision. We can again see the treatment as well as the metadata. The first one was overruled, overruling the cited opinion. The second one is criticizing, and the rest are just simply citing it. The metadata, such as the date and the court, as well as the jurisdiction, allows the user to quickly pick which opinion that they want to further dig into. Eventually, we want to expand this to also include authoritative and non-authoritative opinions, as well as incorporate the appellate chain. And as we mentioned before, our user also use a lot of our API functions. So the citator will also be incorporated into our API, so user can get the bulk outputs in structured formats for their downstream tasks.
Any questions?
I'm curious, Rachel, by using the LLMs for the labeling, what approaches or thoughts do you have in regards to creating like a well-calibrated error prediction? I know it's very hard when you have a label, you can't, put error bars on it the same way. Do you consider asking for a confidence from the LLM for how making that part of the outputs, testing against that? I'm just curious what you did to deal with like different levels of confidence for the labeling.
Yeah, so we did not ask the model to produce a confidence score because the confidence score provided by these models are not deterministic. As you know, these are statistical models. So we don't view them as a deterministic determination on how well the model thinks its predictions are. We analyze it first based on the quotation. So whether the quotation is actually existing in the opinion itself, and whether it's relevant to the cited opinion. And we have the actual human expert annotated labels, so we can use that to produce the metric so that we can analyze which ones are the model continue to make mistakes or fail to make predictions, so that we can analyze where maybe we need to enhance the prompt, or maybe it's a data issue that we can look into.
Yes, I'd be curious to see like the ROC curve on the predictions. I'm just curious, like, because and I don't have a good sense for this.
Yeah.
Because of the LLMs, and as you said, like, it's just all the sort of traditional modes of evaluation are a little. So if you have, I would love to see any.
Yeah,
obviously not now,
absolutely.
but it's just it's
Yeah.
I'm gonna stop talking.
Yeah, the overruled, not overruled, we definitely have the results. It's on our GitHub, and I can share with you later after the presentation. And we're expanding it to the the fine grained classification. We already have some preliminary results, but we need an expanded expert annotated data set in order to produce a more comprehensive ROC AUC curve so that we can analyze it better.
Well, the unbalanced data set creates all this sort of.
Yeah, it makes it weird.
Interesting. Stop it.
Thank you.
Any other questions for Rachel? Okay, so I have a question for the three panelists. So where do we go next? What are the biggest opportunities and open questions related? Don't everyone answer one.
I have a question that's sort of related. How long before you start offering up features that Felix doesn't want to advertise next to?
Oh, and actually, I'm surprised it's there. But that's a timed sponsorship that I think it
Good timing then, to get extra
may
bang
not
for
be
your
there for
buck.
me much longer. So
So that's the answer to that question.
we're a nonprofit, so we're not really in the business of advertising and stuff like that, but one time thing. So
For example.
that's okay. That's on our site. Raise your hand.
I have a question, if we're, is that okay? And I apologize, I came, as far as I was late, about this, sorry. You know, to what extent, so you decided to use the generative AI, work on this. To what extent is this, service dependent on the continued availability of that generative AI at a certain cost level now?
Yeah, so the prompt is designing a way such that we can swap to any model that takes the prompt. So it doesn't have to be a commercial model. It can also be an open source model that we can host ourselves. And on the cost side, currently we're exploring the possibility of just providing one opinion and the list of all the cited opinions so that it can produce output by scanning through the opinion just once. So that substantially reduces the cost of looking through the opinions multiple times. Sometimes you can have 200 cited opinions within an opinion. That means 200 calls, but now we're only doing one call to the model.
Are you expecting the consolidation and prices to rocket or something?
I mean, the general pattern, right, in tech like this is that it goes from free to dependence to, extraction, right?
Yeah,
That's just what I wonder. That's what I worry about with all of it, because we're in that sort of free, let's generate dependence stage, and what happens then?
The Dr. Owen certification.
Yeah.
yeah, I think that's obviously a fair concern. Like currently the costs are going down, right? Like we're still in a process where they're improving and stuff like that. Things are going down. I did an analysis this week actually, because we have a scanning project we're in the process of launching, and using chain of reasoning and all this logic that Rachel has been sharing inside our team. And I think our estimates just for like using it to extract out and organize data without hallucinations, it's about $3,000 per million pages. So like pretty low, I think, cost analysis, just for not for the scanning, not for all those other parts of it, but just from like inputting and pulling things out nicely, so things could double and still be okay. And if things continue to drop, I think I wouldn't be too concerned about it. So, but.
Sorry, go ahead.
No, you want to talk about like biggest opportunities or questions or?
But I just wanted to, I was gonna ask Rachel a question, but that.
No,
you
go
go
for it.
ahead.
No, it's open, yeah.
So what are? Never mind. I'm not gonna ask my question. Go ahead. Yeah. I'll wait.
Okay, so how can law schools, researchers, public interest groups get involved in this? Like, where's the involvement or the path for this crowd?
Yeah, for us, I think one thing is, as I mentioned, we are expanding the data set in order to evaluate the fine-grained classifications which is a highly imbalanced data. You know, not so many cases are, for example, questioned, but there is a lot that's being cited. So we need a pretty comprehensive data set in order to run a comprehensive evaluation. And to do that, we need expert annotated golden standards. So you know, if you want to contribute and are interested or excited about the open source citator, as well as the you know, advancing legal data access, we would invite you to you know, send us an email or fill out the form that's gonna come up right here. The Google form, you can scan the QR code to fill out the Google form, or you can send me an email at rachel@free.law. And you know, we'll go from there. And we would, you know, super appreciate anyone's help in doing this.
And we're fully open source, so if anyone wants to just write some code for us and submit a pull request, I'm happy to review it, so.
You're gonna turn it into the labeling into a CAPTCHA for access. So,
Oh my gosh, we should. Well, first, we're gonna create the dependency. It's free for a while.
Yeah.
Go ahead. So who's gonna push back against this? Who's gonna like say, what's the opposition that we should be looking at?
No one.
Yeah,
We're ready to.
No one without any money.
yeah.
I was just laughing because we like tweeted out, sorry, blue skied out, I'm not saying the other thing. We sent out this link to this expert education forum, and immediately some troll is like, AI, what, it's just gonna hallucinate everywhere. And so that's not really what, you know, what the project is. Like you saw Rachel talk about how carefully
Yeah.
like this is being designed. So I'm not really worried
Yeah,
about
people-
that kind of pushback. But I think you're more talking about like,
Publisher.
yes.
I mean, they're all doing it, right? I mean, you go to Lexis and you can see that purple text up there generating their
Yeah, it's
summaries,
just,
right?
yeah.
You know, and well, I think we're up to 100 lawyers who have published fake case law in briefs, you know.
At least the AIs, we still have to figure out how we do it without the AIs.
Right.
One does not include you.
It
Okay.
sounds like you also have a good number of like, well, you had that slide before, of people who are using the underlying stuff. So there are commercial partners who would find this as a benefit, especially in the API. So there are defenders, maybe there's some money defenders against the money defenders. Money distractors.
Next question, with your infinite money and infinite resources, so this is the this is the citator part, but one of the problems that we, again, as people teaching legal research run into is the citators are only part of the issue of when cases have been overruled or not, and sometimes it's not explicit. Can we develop the next step of, well, you know, this case is actually implicitly overruled by this case, even though the cases don't mention one another?
That sounds really fun for you, Rachel.
Well, isn't that, you know, sort of mentioned and distinguished as for?
No, she's
no,
saying
that's
if they've
Or
never.
talk to each other. So let's say like, you know, you have random case B, which, you know, talks about a particular area of law, and then case A, which talks about the same case, and then case A prime overrules case A. It implicitly overrules case B, but there is no connection between case A prime and case B.
Well, what's cool is that like with it being open source, like someone could develop that, like Lexis and Westlaw have that built in their citators now, like we could do it too. It just would be like an additional feature. And I think you could probably build even more features beyond that. Like there's some, like, what if it doesn't talk about it at all? What if it only talks about like the whole thing, you know? So I think there's more that could be done, even though this piece doesn't exist.
It's a great exercise for students. They'll be able to.
There you go.
If we're adding feature sets, here's just the inverse of that. Is find the zombie laws that would come back into effect after something was struck down. Yeah, you said infinite time and infinite times.
Oh, yeah. Well, I want the thing that forces all the students and lawyers to like remember secondary sources exist, but
Yeah, I mean, those cases are gonna be linked though, right? Because like, A to B and B to C, you know, even though C doesn't mention A, it's still gonna,
No, because B could be like this entirely separate random case, like over here from like 1950, and then you got a 1970 case that might have the same law, but like the reference may be further up. Like they just, there's no immediate connection between these.
It'd just be like, we've outlawed, you know, it could be Roe, it could be Roe, okay, all these cases before
Right.
go out.
Yeah.
Or Dobbs and all these cases come back in.
They call it like the ABC problem. I don't know, catchy. I
Property
guess.
would be a wild deed, right? There's no way to connect them.
So they are connected, but they, like,
But we
B
are com-
connects to A.
Yeah.
And C connects to A, but B is the one that's overruled.
Yeah.
So,
yeah.
anyway, they're connected.
Okay.
And so, but sometimes they don't even mention one another, because like, you know,
Yeah.
they're just gonna be like thinking about very, like, the particular cases that might have been really important in 1950. May not be important in 1970, so that might refer to a whole different set of cases, so.
Yeah.
I think one of the features, you know, that is sort of that we're thinking of expanding to is also analyzing the holdings, the specific area of law that the opinions are related to. So I think that should solve some of the problem.
Yeah, that sounds great.
Yes, I don't have.
I mean, particularly if it could analyze all these and create clusters, and then you could visualize and see
Yeah.
where you've got these
So then we ravel it,
separate sub-universes.
so then you can like make your new ravel and.
So you're making head notes next, is that?
Like all these people that aren't doing the work of creating new work and projects for y'all.
It's in the GitHub issue queue and we'll work through them in our sprint.
Well, that's
So
the
I-
problem, like, you know, once ravel gets bought, where's the innovation happening, right? So.
I have I can't see the Zoom Q&A, and so I don't,
Albert walked out.
but I got fed one of the questions that someone has. So how do you handle lower court opinions which aren't often cited? So like, how are we dealing with like reverse?
Yeah, so that's one of the you know, open opportunities that we're gonna look into expand to later on. And it's actually could be quite difficult, you know, because the higher court may just mention, oh, this lower court, you know, we're reviewing them and reviewing the opinion from this lower court, and you know, it's related to these people, but it doesn't actually say what the case name, or you know, it could be that it's very new and there's no citation yet. So in these cases, you know, for the ones we do have the citations, we would be able to link it. For the ones we don't have citations, then we're looking to link the docket. So that we can get the lower court opinion, and you know, the eventual dream, if we had infinite money and infinite time, is to be able to link all the way from the lower court to the higher court, highest court, you know, including the reversals and affirms. Yeah, with the appellate chain.
And we are working on that,
Yeah.
you know, but
Don't have
lower,
unlimited time.
it hasn't reached the top, but it's getting close to the top of the list of things to do, so.
What hardware are you using for all this?
Hardware.
Yeah,
Oh,
like, are you like? You have like your own system, do you are using something in the cloud?
oh, take this?
You can take it?
Yeah, sure. Well, 6 years ago, we were self-hosting, which is crazy. And we transitioned to AWS.
That's what.
Yeah. Which is wonderful.
You're doing a lot of load balancing with your servers these days.
More and more interest every day.
You have some questions online.
Thank you, online.
How does it happen? This is its first time, this is the first time anybody's actually asked questions online for the whole conference. So let me see.
Look at my mother.
I don't know, how do we want to do this? Can you see those on the, go to the, if you go to the Zoom.
By the way, all of our data is
See
open.
anything?
Yep.
Yeah,
APIs.
so
Okay,
so
I'll
those
ask
are the
them.
questions.
Yeah.
There you go.
Okay, so Jonathan Franklin is asking, how do you generate the F1 score? Is there a gold standard you used and compared your results to that? do Lexis and Westlaw ever differ in citation results?
Yeah,
So-
our F1 score is generated through golden standard data set. The overruled, not overruled binary classification, we already have the golden standard data set, which is reviewed by the experts. So, with that, we're able to generate the F1 score, and with the fine grain classification, this is where all the legal experts, we would like your help to generate the expanded data set. Currently, we only have 1,000, and we need more in order to generate the F1 score on a more comprehensive basis. Do Lexis and Westlaw ever differ in citation results? We didn't run the analyses ourselves, but there are papers out there that do analyze whether Lexis and Westlaw differ, and based on the papers, I think the answer is yes.
Okay, so we discussed the lower courts, and then Bill, can you talk more about the scanning project?
Yeah, one of the things that we scrape from, I should really have this number, I don't know, 190 different court websites across the country. Including also we have our recap database, which is the crowdsourced collection of dockets and opinions from Pacer. I think it's 100 million dockets that we have, and one of the challenges that we face is we don't have citations or new citations, right? We have everything back to the 1600s forward from the Harvard case law and other data sets. We have some from Columbia, but all of our new opinions lack those citations. And in many cases, the courts don't even know what their citations are. I'm a child of Alabama, so I'll be looking at Alabama, who just sends off their opinions to West and never publishes or posts their final citations on their website because they just don't even know. They don't care because they don't have to pay for it or do anything else. We've begun exploring and experimenting with scanning reporters to extract that up sort of and into our system, pulling out all those citations and all the pen sites and pagination that we need. So that hasn't launched yet, but we have a data set that we're working with to use LLMs to help us get over the hump with that process. So it's been to take over the most important cases and continuing to scrape with immediacy, things like that.
It's also why we're pushing in my session yesterday about neutral citation, because you can see the problems that we're running into because courts don't have this available. All right, we have a few minutes. I think we have all the Q&A online. So if you guys have any, if you all want to add anything.
Well, and check out our APIs. They're open and free. We also have databases on judicial financial disclosures and judges and all this other stuff that I know law students probably enjoy diving into. So filters and things.
And the oral arguments, that's kind of cool.
Oral arguments, we've transcribed millions of minutes of oral arguments. My dream is to link those directly into our search results so that if someone wants to hear people arguing about a particular case law, maybe they can actually pull up the actual argument in front of a judge. I think that would be a nice addition down the line. So
Yeah. Opinions, oral arguments, what is about your brief coverage?
we don't scrape any dockets for lower court dockets or sort of brief memos. We have a lot of them from all the most interesting cases in the federal courts because we basically have everything from Pacer. Whenever someone goes to something that's important or newsworthy, it's uploaded into our system. So we don't have a wide breadth of them, but we have a very nice subset of important ones, right? If you want to read about Donald Trump's legal cases from a couple of years ago, got every single filing, every single document, so.
Okay, so if you have questions, our panelists will stick around for a little bit, but here is our content information, maybe. Here we go. So thank you all for coming. Thank you, our panelists, for presenting. So thank you.
all got your work cut out for you.
Yeah, but you're doing really great work. I
No.
love. I don't know, I don't say this enough.